This is Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. Donald Trump just filed in the Southern District in Florida quite a bizarrely styled motion. It's called a motion for judicial oversight and additional relief. I'm going to break down what we can glean and try to understand from this motion, but it is a very bizarrely written motion. So, as you are aware, there is the search warrant that was signed by the magistrate judge on August 8th, and proceedings have taken place as recent as last week before Judge Reinhardt, the magistrate judge, about unsealing the affidavit in connection with the warrant and the return. Those documents are already public. The affidavit isn't, as Judge Reinhardt pointed out today in his order asking the government to redact portions of the affidavit that they believe is confidential, and perhaps the whole affidavit may have to remain confidential if it reveals too much information about the potential confidential informants and the sources and methods of the FBI. But Trump has filed nothing in that case with that magistrate judge. There's no pleadings. There's nothing about unsealing the records. All Donald Trump has done is have his lawyers go on TV and say that they've demanded that records be unsealed. But when it came to actually what happens in court, they filed nothing before Judge Reinhardt, who's a magistrate judge. And magistrate judges are appointed by federal judges. Federal judges are Article 3 judges who are confirmed and appointed through the presidential appointment and confirmation process, ultimately through the Senate, who confirms the appointee. And so this motion that's filed is before a judge who's actually a Trump appointee who got assigned it. There was some discussion about whether this was actually filed in Fort Pierce so it would go before a Trump judge. That's not the case. Sometimes it's just assigned randomly. It happened to go in front of Eileen Cannon. Eileen Cannon is a Trump appointee appointed in 2020, and this Article 3 federal judge in the Southern District of Florida will be hearing this motion for judicial oversight and additional relief. Now, the strange thing about what this motion is one, it's filed 2 weeks after the search warrant at Mar-A-Lago. So many of the issues that are raised here may be moot because the Department of Justice and the FBI have had the records. They have their own what's called taint team, which goes through and reviews the records if there are potential privilege claims before the actual investigators who are on the case and investigating the crimes, in this case, violation of the Espionage Act and violation of obstruction of justice statutes. Before those investigators get it, the taint team looks at it, and now 2 weeks later, the Department of Justice and the FBI probably have reviewed all of the records, and because this hasn't been filed immediately. But what this motion asks for is that the judge, the federal judge, appoint a what's called a special master. A special master is a retired judge or private practicing lawyer, a judge who's no longer sitting on the bench, who's supposed to be an independent person who goes through the records and then prepares a report to the federal judge about whether documents were privileged or not privileged so that they could determine what documents the government should have. The issue and the problem here is that Trump didn't file this motion and request a special master until 2 weeks after the search of Mar-a-Lago. Any competent lawyer or any competent person who was concerned about a search, you file this immediately. And then actually, if you look at the substance of this motion for judicial oversight and additional relief, you almost ask, well, what is this motion? Well, are they asking for an injunction? I mean, they mention in this motion to enjoin or stop the Department of Justice and the FBI from further going through the records until the appointment of a special master. But why isn't this styled as a request for an emergency injunction or a temporary restraining order? Why is it phrased as a motion for judicial oversight? Also, as I look at this document, in any type of motion like this, you would have signed and sworn affidavits under oath that set forth the facts. A bare motion on its face that just has words and arguments in and of itself is not cognizable evidence before a court. There has to be affidavits or declarations under penalty of perjury. Here, the exhibits that are attached to this motion for judicial oversight and additional relief are the warrant and the return, but there's not even an affidavit about that, yet alone an affidavit that sets forth the facts that are being discussed in the motion. And when you go through the purported facts facts that are being discussed in the motion, in typical Trump fashion, they're alternative facts. And one of the sections is basically entitled "Trump is being treated unfairly," and it talks about Russian witch hunt and uses all the stupid language that Donald Trump likes to use in these motions that have no bearing on the actual motion or on any facts, which seems more to be, red meat to throw to his base. But when Trump talks about these events that occurred, they have glaring gaps in them. He talks about leaving the White House in January of 2021. Then you fast forward in the motion basically to January of 2022, when the National Archives comes and takes these 15 boxes at Mar-A-Lago. There's very little discussion about what took place between them. Then you basically fast forward with a grand jury subpoena in May, and then an appearance by the top counterintelligence official at the Department of Justice in June, without really any discussion about what took place before them. There's no mention here that Trump's lawyer filed a declaration to the Department of Justice stating that all documents were turned over, when in fact we know the documents aren't turned over. And then it basically fast forwards after making Trump appear in the motion. "Oh, I told the Department of Justice whatever you want. I'm here to help you." It obviously doesn't talk about all the interactions that actually were taking place, including that potential false declaration that was submitted to the Department of Justice. Then it goes and just talks about the search warrant being executed on August 8th without any other information or any other discussion about what was actually taking place between that time. There's also a very alarming and strange part in the motion as well, where you have a reference, and we've heard about this reported before, but here the motion actually says this. It talks about how a Trump lawyer reached out to Merrick Garland and basically said, "You need to turn down the heat." This is what the motion says. On August 11, 2022, counsel for President Trump spoke with Mr. Bratt, who's the top counterintelligence official at the DOJ, by telephone. The first item of discussion was a message from President Trump to Attorney General Merrick Garland. The message was as follows: President Trump wants the Attorney General to know that he has been hearing from people all over the country about the raid. If there was one word to describe their mood, it is angry. The heat is building up. The pressure is building up. Whatever I can do to take the heat down, to bring the pressure down, just let us know. And so literally you have obstruction of justice being admitted to in this motion. Perhaps that's why no one signed an affidavit or declaration under penalty of perjury to talk about this thing. So I guess that they could later deny that this actually happened. But that's an absurd thing to put in a motion. Now, what do I think is going to happen? Well, the judge that got this case, as I mentioned earlier, is a Trump appointee, someone named Eileen Cannon. She was appointed by Trump in 2020. She's been a member of the Federalist Society since 2005. She was part of the wave of very young right-wing judges who Trump appointed while he was president, and she's hearing these facts. Now, the procedure that's supposed to be filed in something like this was not filed, as I mentioned, no affidavits. And I also believe it's moot because the DOJ probably has reviewed all of the records before. Do I think at some point in time a special master could have been appointed? Well, when there's usually questions of privilege, sometimes a special master does make sense. But here, I think the amount of records that exist and the boxes that are at issue probably don't require a special master. But I could see a special master appointed. I think it would backfire on Trump if a special master is appointed, because they're just going to prepare a report back to the federal judge saying what documents are top secret, compartmented, and secret, sensitive, compartmented information are our nation's highest secret. So I think that report would not be helpful. And one of the most glaring omissions here in this motion is Trump saying there was no top secret, sensitive, compartmented information at Mar-A-Lago, right? That's the most basic thing that you would put in this motion if you were, trying to object to the search that took place. There was no top secret, compartmented information and sensitive, compartmented information. Nowhere does he say that. And what Trump appears to be asking for, he appears to be citing under Federal Rule of Criminal Procedure 41 sub G and sub H. One is a suppression motion, which is to suppress evidence from going to a jury in a case where there's an actual indictment, a criminal case taking place. to basically say documents were obtained unlawfully, they're the fruit of the poisonous tree, and a jury shouldn't see these records. The other is a motion to return seized property, which appears to be what this is under. But again, Trump has filed no documents before the magistrate judge. He's brought this motion before the Article 3 federal judge. There's no affidavit. There's no declaration here whatsoever. There's no claim that these top secret, sensitive, compartmented information belongs to Trump. So we're going to follow what this Article 3 judge, but ultimately what's going to happen, I think, the Department of Justice is going to file very soon a motion that's going to point out what a frivolous legal motion this is, what a horrible legal motion this is, doesn't follow the rules, and they're going to point out all of the gaps. One of the things the government may have to do, though, is file that motion under seal, which means to file portions of it confidentially to protect the sources and methods, which Trump may then rail on and go, see, they want to keep it secret. But it's because it's an unserious motion at the end of the day that Trump filed. And it's probably moot because the Department of Justice probably has reviewed all of the records by now, 2 weeks later, where a special master to determine privilege may have made sense a little bit earlier, but Trump didn't file anything a day after. Any good lawyer would have filed something if you wanted to contest it. So that's the breaking news alert regarding Trump's motion. Hope I broke it down in a way that you can understand the kind of common sense terms. Make sure to hit the subscribe button. We appreciate all of our supporters and support independent media by hitting the subscribe button. This has been Mycelis with an update. We'll keep you updated on future developments here. Talk to you soon.
Hey Midas Mighty, Emma Silverman here reminding you to make this November Rovember. Check out the new MeidasTouch Rovember t-shirt collection at store.MeidasTouch.com. That's store.MeidasTouch.com. Hurry up and get your Rovember t-shirt before they sell out. Let's go.